Uh, so welcome to our discussion of Ghana legal system. We are still discussing sources of law in Ghana part 2. Yesterday we discussed part 1, in which we concentrated on the Constitution as a source of law in Ghana. This afternoon, a few minutes, we'd like to discuss or explore enactment by Parliament as a source of law in Ghana, still within the, the scope of sources of law as per Article 11 of the 1992 Constitution. And just to let you know that the material I'm using for teaching is actually extracted from Chapter 3 of Volume 1 of our work, Ghana Legal System and Legal Method, the second edition. So I think in a week's time, next week, I think they should be out. Yeah. So first of all, what is an enactment? Now, as you remember, if you go to Article 11 of the Constitution, we are told that the sources of law in Ghana are the 1992 Constitution, enactment made by the Parliament under the Fourth Republic. And then we have the existing law, then we have the orders and rules, and then we have like the common law of Ghana, which is made up of like the common law, rules of equity, and then customary law. So we have discussed the Constitution, the first one, of course, the supreme and primary law of the land. So we want to look at the other item on the list. Of course, the point should be made that apart from the Constitution itself, which is primary law, the basic law, and for that matter, it enjoys primacy, it enjoys supremacy among the various legal norms in our legal system. Quite apart from that, it is not a simple matter to say that because in Article 11, after Constitution, the next one is Act of Parliament, followed by the existing law, and so on and so on, so that their importance is according to that or that. No. The Constitution is the only one which automatically has the prominent place, and there's no doubt about that. But for the rest, there are a lot of authorities, Supreme Court, which suggest that it is not really necessary to try and rank which of the other sources of law, apart from the Constitution, come next, and so on. So let's keep that in mind. So we have just selected enactments just because it's second in the list, not because it is important than the existing law or the other components as it were. So if you look at the Interpretation Act, enactment is defined as an act of Parliament, a statutory instrument, constitutional instrument, or a provision of Act of Parliament. And a provision of Act of Parliament can legitimately be called an enactment. In the same vein, the provision of statutory instrument can legitimately be called enactment, and the same thing applies to constitutional instrument. So therefore, you see that the word enactment is used for a whole, and at the same time, it is used as a part of a whole. So it serves as both referring to a whole thing and part also of the same thing. But we are going to focus on Acts of Parliament. And if you look at Chapter 3 of our work, that is a point that we make. As I told you, these discussions are extracted from the Chapter 3. And in the second edition of the work, we've substantially, we've rewritten most of the things and very expanded and quite detailed. Yes, so in terms of importance of Acts of Parliament, of course, as I said, if you are going by the list, right, the list, Then you say that immediately after the Constitution, the next one is the Act of Parliament. And for that matter, there's that temptation. So there is that temptation please just a minute. Hello. Yes, so sorry for the break. So we will look at Parliament and the role that it plays within lawmaking. And in fact, Act of Parliament itself, as we will notice, is a primary legislative instrument, not legislative instrument as in LI. No, we're using it in a generic sense. That is a legislative material for, just to be cautious, because if you hear of LI is legislative, that's a subsidiary legislation. We are not talking about that. We come and discuss that later on. But we are talking about Act of Parliament as the means by which the will of the people is translated into legal norms and directives. And certainly Parliament is the meeting place of representative of the people. And whatever comes from there, that is what the people of Ghana are more or less saying. So we are going to limit our discussion to Act of Parliament and try and understand its role, implication, how it is made within the context of Ghana legal system. So in terms of constitutional setup and its relationship with the Act of Parliament as a source of law in Ghana, we ought to remember that Parliament is the sole legislative authority. It has the exclusive authority to enact legislation in Ghana. So, of course, we appreciate that there could be delegation, but if you're talking about the primary entity with the primary and the core business, the core mandate of lawmaking, that is Parliament, and not any other entity, not any other arm of government, not any other functionary within the governance apparatus or architecture. So let us keep that in mind. So Parliament is tasked with the responsibility of creating laws that govern the country. And if you look at the Constitution, despite the fact that Parliament has been given the law-making power, the legislative power, now that power is supposed to be exercised within the limits set by the Constitution. So let's keep that in mind. And yes, if we are talking about constitutionalism, if we are talking about checks and balances, we have to remember that despite the fact that if you are talking about separation of power, despite the fact that Parliament has been given legislative power, it doesn't mean that it can behave like the octopus and spread its tentacles here and there. No, it has to exercise its mandate within the letter and spirit of the Constitution. So that is very important. And of course, there are limitations and oversight, which is exercise over Parliament's authority, so as to ensure that Parliament's authority is not absolute. So legislative activities of Parliament are subject to judicial review. If for nothing at all, there are a lot of times in which Supreme Court has had to strike down certain legislation as being unconstitutional. Either it was made without compliance with the procedure prescribed by the Constitution, or whether in terms of substantive content, what that legislation has actually done actually undermines or is an affront to some substantive prohibitions or some substantive limitation in the Constitution, as it were. So all those things actually provides the basis for the Supreme Court to exercise its power of judicial review over the legislative activities of Parliament. And as we move on in this discussion, you notice that the Constitution has outlined certain specific areas where Parliament is limited. That is to say that, yes, Parliament can do certain things, but it has to comply with certain procedures, or there's an explicit prohibition. We'll be seeing that very soon. Again, we know very well that when it comes to governance, the state is governed through laws. If a government is elected, a government cannot exercise its power unless it has the requisite laws. Even when a budget is prepared, the budget cannot be implemented. It has to be approved by a law. Appropriation bill will have to be passed. Everything what is done in the country is according to a law. So that is why we have a rule of law-based society. And if it's according to law, then the Parliament, by its legislative role, has got significant role to play in governance. And as you can see, everything. The executive cannot do things. Even if you are going to take a loan, they need Parliament to pass resolution, they need Parliament to pass the necessary legislation, as the case may be. But Parliament also works in harmony with other arms of government, the executive and the legislature, to ensure balanced governance structure and adherence to the rule of law. We need not belabor the point. With respect to executive, if for nothing at all, we know that the ministers are supposed to be vetted and approved by Parliament. And again, the government headed by the president is supposed to give state of the nation periodically to Parliament. Parliament also has the power to summon the executive to come and speak to any question that it may have. And then Parliament has also got standing committees, which mirrors the various portfolios in government. And then Parliament has also got the standing committee, which is responsible for overseeing like the judiciary, as it were, matters related to the judiciary. So there's that kind of relationship. And even where Supreme Court judges and the Chief Justice are appointed, you see how Parliament plays a role in their appointment process. Now, we have to remember that the general powers of Parliament with respect to legislation, making law, the enactment process, and all that are subject to important limitations. And of course, we need to make the point that if we look at the history of Ghana, right, especially during the immediately after independence, the kind of parliament that we had, and largely also carried into the First Republican Constitution and 1960 Constitution, Parliament had more or less unlimited power, absolute power. It could do almost everything, similar to the Westminster Parliament. And that is why we have the expression that in Orthodox Westminster, the Parliament can do almost everything except to change a man into a woman or a woman into a man. But with now transgender surgery and all that, I think that saying is no longer even valid, as it were. But that tells you how Parliament is powerful in that part of the. Yeah, sorry. Yes, but if you look at the dispensation that we have under 1992 Constitution, the parliament that you have is remarkably different from what we had in the past, in the sense that, especially immediately after the independence, in the sense that parliament is subject to important limitations, important restrictions and prohibitions, as we notice. So the Constitution itself delineates Parliament's powers, and for that matter, the powers of Parliament are not unlimited. The Constitution itself, we say, we go to Article 93 and all that, yes, the legislative power is vested in Parliament, but it shall be exercised in accordance with the provisions of the Constitution, so to speak. Now, apart from the Constitution itself, which in creating the power of Parliament has also circumscribed it by saying that that power is subject to the letter and spirit of the Constitution. There's also another constitutional limitation on the power of Parliament. Of course, as we have mentioned, through judicial oversight. And Parliament, people can go to court and say that a particular legislation Parliament has made and so on should be struck down as being unconstitutional because it's sin against certain provision of the Constitution or the spirit of certain provisions of the Constitution, as the case may be. So there are explicit or key legal restraints on the power of Parliament. So we have prohibitions. Parliament, for example, cannot enact laws that will establish a one-party state or make retrospective laws, because as you look at the history of Ghana, we've learned our lessons, during especially the first, Republican Parliament, as well as even to some extent, some of the things we witnessed under the 1969 Constitution. So there is explicit prohibition. Yes, Parliament, you have the power to make law, but you cannot make any law which will apply to things which have already taken place. So that is a retrospective legislation that is not allowed. And again, we have the directive principles of state policy, chapter 6 of the Constitution, and that also serves as an important controlling mechanism on legislative power, because you notice that the directive principle of state policy is supposed to be a blueprint, the vision of the kind of society that we are trying to build as a people. And for that matter, when Parliament is exercising its legislative power, it must do so in a way which will advance the principles of directive principle of state policy rather than undermining same. So let us keep that in mind. And there are a plethora of authorities in which the Supreme Court has had to exercise judicial review over legislative power of Parliament. There are a lot of them, the NPP against the Attorney General, 31st December case, District Chief Executive case. I mean, so many cases. We can get even over 100 cases. And all these things are meant to ensure that we have a proper balance, in how power is allocated between the various branches or arms of government. And this seeks to prevent any particular branch from wielding excessive control. And of course, this restraint also ensures that the rule of law, which we have enshrined in the preamble to our Constitution. But if you look at the preamble of our Constitution, it says that we are seeking to ensure that we secure blessings of liberty and rule of law. So the rule of law, how do you achieve it? If you have arrangement like this, that yes, Parliament has been given power to make laws, but then its power to make laws is subject to the provision of the Constitution, is subject to the directive principles of state policy and so on. That way, you are advancing democratic governance in a way which enhances rule of law, in a way which protects citizens' rights. We can get so many cases which illustrates how judicial review has been exercised over power of parliament to make laws. Remember the 31st December case. Of course, there was a law, despite the fact that it wasn't the fourth Republican Parliament who passed that law, but so long as it is law, it's Parliament which made it, whether old Parliament or old entity like the military regime having the power to make laws and all that, it is a law made by the legislature. And that, among other things, declared the 31st December as a holiday, and then it was celebrated on the public resources. In the 31st December case, you see how that was challenged. And the court made the point that Parliament does not have unlimited power to legislate on anything, and that we have supremacy of the Constitution. In the same vein, the Ghana Bar Association against the Attorney General, if you remember the Justice Alban case. And over there, for example, the Supreme Court, the Alban case, Supreme Court made the point that the concept of parliamentary sovereignty in Britain, which says that Parliament has absolute power to do whatever that it wants to legislate on, is completely alien to Ghana, because as we have seen, our Parliament does not have absolute power. The power of our Parliament is limited. So all legislative acts are subject to judicial review. And we can also mention the case of Adolfo against the Attorney General. A lot of cases which we can mention. And all these things actually ensure that we have proper checks and balances, as it were. We've mentioned that there are prohibitions, that is no-go area, right? Areas where Parliament, despite having legislative power, has been banned or has been prevented from extending its lawmaking power. What are some of these? We've talked about prohibition against making Ghana one party. So you look at Article 3, Clause 1, it's quite explicit that Parliament cannot pass any law which will establish Ghana as one party state. Then if you look at Article 56, among other things, Parliament can also not legislate to impose any religious or political program on the people of Ghana. Then Parliament can also not pass law that would retrospectively overturn decision or judgments of the court. If you look at Article 19, once a court has decided, especially affecting people's rights and liberties, Parliament cannot make a law to try and overturn the effect of the decision of court. And again, when it comes to chieftaincy, for example, if you look at Article 270, Clause 2, we are told that Parliament is restricted from enacting law that interfere directly with the institution of chieftaincy, maybe such as conferring or withdrawing recognition from chiefs. So if you look at the various crises around the country, previously Dabong, now Resolve, now Sampa, and all that, Parliament cannot make law to try and resolve those matters because the Constitution has denied Parliament such powers. And every provision in the Constitution has got a history. Most of the things that we have, they don't just happen just like that. We want democracy to stay, and look at it. I mean, you have succeeded in having constitutional democracy, 30 years, a little over 30 years. The current constitution came into force 7 January 1993. We are in 2024, so about 31 years, so to speak. Now, that has been possible because of some of these arrangements. So these arrangements have got cultural and legal rationale. which include preservation of the democratic principles, as we have ensured that, yes, you need to have pluralism. You need to have multiple political voices, and that can only be done where you have some of these arrangements. And of course, cultural diversity too should also be preserved. Judicial independence, respect for traditional authorities. Now let's come to what is really important to us presently in terms of sources of law. The lawmaking process in Parliament, what is it? Now, we know that Parliament has the power to make laws, and Parliament exercises its powers by passing bills. What is a bill? A bill is simply a proposed legislation, a proposed law to go through the process, and then it will become an act of Parliament. So a bill is drafted by government ministers or ministries, or sometimes you have a private member bill, like the current anti-LGBT legislation. That was a private member bill, in the sense that it's not the government which initiated and sponsored it. It was some individual or group of MPs who initiated that. Now, it is a requirement in terms of Article 106 of the Constitution that every bill must be accompanied by an explanatory memorandum. So every bill must have an explanatory memorandum. And the explanatory memorandum is supposed to tell us the intention or the objective of the bill, the problems, the mischief which the bill is trying to rectify or address, and the solution it proposes, or the changes which the bill proposes. All these are supposed to be reflected in the memorandum. So therefore, when you read the memorandum, it's supposed to give you a very good background of why that law was made, or what led to the making of that law. Now, when you have the bill drafted, before the bill will be introduced in Parliament, it must be published in the Gazette at least 14 days. So you publish it in the Gazette. The Gazette is the official mouthpiece through which the state communicates to its citizens and to the world. So that when information is put in the Gazette, it is presumed that everyone has been told. And one will argue that it's part of the basis for the maxim that ignorance of the law is no excuse, because the law is said to have been published in the Gazette. Of course, as whether you've seen it in fact or not, that is beside the point. But before the bill will go to Parliament, at least 14 days, it ought to have been published in the Gazette. Then it will go through the first reading in Parliament. So the first reading means that the bill is formally introduced in Parliament and it is read. So the first reading will be general debate over the bill's principles. And MPs will not get into the specifics, no. So the first reading, like the general vision of the bill, the general philosophy behind the bill, the bigger issue which the bill is trying to speak to, those are the matters which will be debated by the members of Parliament when the bill is read for the first time. And usually, there's what we call the long title, right? The long title of the bill. The long title of the bill is supposed to capture the purpose or the objects of the bill. So when it is properly crafted, when the bill is read for the first time, usually it's even like the long title, which may even be read, and that will provide basis for general debate by MPs. Now, after the first reading, the bill is referred to appropriate parliamentary committee. So we have what we call the committee review or the committee stage. Now, if you go to Parliament, we have what we call standing committees, permanent committees or standing committees. These committees mirror the various portfolios which are usually held in government. So that we have like the, let's say, the public accounts committee. We have a committee on probably youth and sports. You have committee on maybe defense, and committee on interior and things like that. So we have the committee on constitutional and legal affairs. So when a bill is introduced in parliament, they will quickly determine this bill under which committee's mandate does it fall. And after the first reading, they refer it to the particular committee whose mandate is implicated by the bill. And the committee is supposed to examine the bill in detail and, if necessary, make amendment or suggest amendment to the bill. And the committee, at the end of its work, will craft a comprehensive report regarding observations that it has made on the bill, any necessary changes that it is suggesting for attention of the entire parliament, the plenary assembly, as it were. Then we have like the second reading. So the second reading focuses on the detailed debate on the bill principles based on the committee's report. So mind you, the first reading, just general debate. You don't get into the specifics. Then you make reference to the appropriate committee to look at the bill and make the necessary observations, suggestions, and all that. And then the report is taken to parliament. And when the report is taken, the bill will go through second reading. So during the second reading, MPs have been armed with the report from the appropriate committee, which look detailed into the bill. And then they will debate the specifics of the bill, informed also by the committee's report, as it were. Parliament will vote on the bill if the bill is successful. At each stage, it will have to be some level of approval. Parliament will have to vote on it, and then it will be escalated to the consideration stage. So if it's successful at the second reading, it will be escalated to the consideration stage. And the consideration stage involves a clause-by-clause examination of the bill. Now, when I say a clause, usually within our legislative drafting tradition, when you have a bill, right? A bill we have said is a proposed law. The divisions in the bill are generally called clauses. We don't say sections. If you have to use the proper language within our legislative tradition. So the smaller divisions in the bill are just called clauses. So during the consideration stage, the entire house, that is the plenary house or plenary assembly of parliament, will walk themselves through the bill, clause by clause. And during that time, where amendments are necessary, members of parliament can suggest amendments, and then it will be reworked into the bill. So the consideration stage is actually tedious, because if you have 40 clauses of the bill, each of them will have to be examined, clause by clause, word by word, as it were. And as I said, amendments can be proposed at that stage. Then, after the consideration stage, the bill will go through the third reading. And the third reading, after the consideration stage, the bill will have evolved. The various amendments made and all that will have been incorporated. And then we have like a refined version of the bill, which will be significantly different from the bill when it was first introduced in parliament and all that. Now, in its refined version, the bill will go through the final debate. The final debate, that's the third reading, after which there will be a vote on it. And if the requisite majority endorses the bill will be forwarded to the president for presidential assent. So that is how it is. And the presidential assent, if you look at 106 clause 7, the president will review the bill and can decide to assent to it by signing it into law, or can refuse to assent to it. Now, as we speak now, at least this aspect of the law relating to lawmaking in Ghana is being tested in the cases before Supreme Court with respect to the LGBT bill, as you can see. Now, the president can make referral or veto. If the president has objections to the bill, you can send it back to Parliament and accompany it with his recommended amendments and give reasons. Or the president can refer it to Council of State and for advice as whether he should agree with what Parliament is saying or not, as it were. Now, when all those matters have been taken care of and there is no impediment, and then the president has given presidential assent, the bill is published in the Gazette and it becomes law. So in a nutshell, that is what the lawmaking process in Ghana entails. But before we finish, we need to also appreciate that we have certain special kinds of bills which have special procedures. So for example, if you take a financial bill, like a financial bill, that is any bill which is related to taxation, public expenditure, or financial obligation of the state. So if any bill which is going to have financial obligation of the state, it's more or less like what they're talking about, financial bill. And now, if you look at Article 108 of the Constitution, there is a stipulation to the effect that no financial bill can be introduced in Parliament unless it is introduced on behalf of the president. And mind you, in terms of Article 57 and 58, the president is the head of government, the head of the executive, the head of government. Now, why is it so? The president is the one who has been given the political mandate to lead the country, including using the resources of the country. So if there is any law whose implementation is going to have impact or is going to have implication for the public purse, for Ghana's national coffers, then it must come from the president, or must be with the authorization of the president. Otherwise, it will not be successful in terms of Article 108 of the Constitution. Then we also have what we call the urgent bills. Urgent bills, sometimes what we call the certificate of emergency. And those bills are needed to address unforeseen circumstances. And you may not have the luxury of time to go through all the elaborate time-bound procedures of passing the bill. Remember, during the imposition of Restorations Act legislation, that is during the COVID-19, a bill or law was made without Parliament actually going through the full gamut of passing a bill into an act. So that can be done under the certificate of urgency, as it were. And Parliament has got its own procedure, which enable it to bypass some of the standard procedural stages that one will have to go through in order to pass a bill. And within that context, it is possible for a bill to be introduced without even prior Gazette notification. As you remember, we said that before a bill we even go through first reading. It must have been published in the Gazette at least 14 days. But where you are using certificate of urgency, you may be permitted to dispense the requirement of standard Gazette notification. And the bill, in appropriate circumstances, can even be probably passed on the same day that they are introduced, depending upon the exigencies of their situation, as it were. Of course, these special procedure for financial and urgent bills are also subject to controlling mechanism. So the bills will have to be, of course, closely scrutinized to ensure that the budget statement which the government introduced, which Parliament will have approved, because that serve as the budget statement serve as, if you like, your economic blueprint for the particular financial year. So that if you are going to Parliament with any bill concerning imposing financial burden on Ghana, you need to demonstrate that it falls in line or it aligns with the budget statement which will have been approved as it were. And of course, regardless, the courts are there to exercise judicial review over the process, depending upon the circumstances. Now, let's talk about the last aspect of enactments as a source of law in Ghana. Repeal, revocation, and amendment. Amendments. Acts of Parliament may be amended in order to update, correct, or enhance the existing law. I mean, that is part of lawmaking. And this can be initiated in the same way that bills are actually made. And you go through the same legislative process for passing a bill. There can also be a repeal. And a repeal is where you have like a complete removal of an existing law, either because maybe the law is no longer fit for purpose, it is redundant, outdated, or it's just deemed inappropriate. Of course, revocation and repeal are more or less the same. And that is where you are cancelling a specific statutory instrument or provision within Acts without actually dismantling the entire law. Now, if you take where there has been a repeal, you ask yourself, so what happens to things or transactions which took place or which existed before the repeal? Well, upon repeal, the revoked law ceases to govern transactions which will occur after the repeal, but not before the repeal. Repeal is usually prospective. So let's keep that in mind. It's prospective, meaning that the effect of it is towards the future. Things which will occur after the repeal are no longer bound by the law which has been repealed, as it were. And if we look at the section 34 of the Interpretation Act, for example, it specifies that repealing a law does not affect any right, obligation, or liability acquired, accrued, or incurred under the repealed law. So, supposing you have a case in court and the matters which are being litigated are based upon a certain legislation, which in the course of time are repealed, it doesn't mean that automatically the case in court has become useless. No, because the transactions which the parties are litigating over actually transpired or occurred at the time that that legal regime was enforced. So to be examined within that context. So that kind of preservation of past rights and liabilities, or later on when you learn statutory interpretation, there's what they call the doctrine of accrued rights. no, your right will have accrued before even a legislation is repealed as it will. Now, if you take the company's code and at 179, you'll notice that it's been replaced by the Companies Act 2019 Act 992. And that is a good example of a repeal. So the whole of it is repealed, and then you have actually replaced it with another legislation as it were. So at this stage, I will take maybe questions or issues of interest which you may have. You put up your hand and then I will release the mic for you. If you have anything, put up your hand, I will release the mic for you.